Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. This semester, I'm posting on First Amendment law. And wow, we have covered some very interesting things. We've gone from the basic rules that pure speech is protected from content regulation by the government unless the government meets a very high standard, that pure conduct is outside the reach of the First Amendment, that the court said some speech has such slight value and can cause such great harm that it is placed in unprotected categories that government can regulate with a lower level test. But then the court even carved out a test in the middle for certain types of speech. So what we're doing, we're concluding here just a couple of topics, and then we're going to look briefly at the religion clauses in the Constitution. My course is primarily about speech with some mention of the Establishment Clause and the Free Exercise Clause. We also have some other courses at our school that more specifically address law and religion. So we're finishing the topic today, then we'll do the religion clauses, then we're going to have some excitement coming up in a few weeks. Well, not that this is not exciting. I know it's exciting, right? In a few weeks, my students who are studying remotely, will take a little take-home exam. I'm going to give them a week. It's only a 10-page essay, right? And after that, they will each write position statements on current First Amendment issues, current First Amendment conflicts. They get to choose the First Amendment conflict. They get to choose the position they want to take. I'll tell you more about that a little later. So it's going to be exciting, and I'll come in each week once we start their presentations and tell you about what they are talking about and how they think the conflicts ought to be resolved under our Constitution. But for today, I want to talk with you about one of our remaining topics called government speech. Government speech. You didn't know the government had a right of speech, did you? We've talked about individuals having the right of speech. We looked at the media, the press. We considered corporations having a right, some right of commercial speech, and also under Citizens United, some right of, a right of political speech. We've looked at all different types of individuals or entities having some protection under the First Amendment. We said when government regulate the content, then that becomes suspect. However, we have not talked about government being allowed to have a message or being allowed to speak a position. And in the cases we're about to talk about now, you will see where the court has also recognized that government has a right of speech. Now, let me just say two things as an initial point. When government speaks and asserts its right to speak, you should always look to see if there are some other constitutional rights being infringed upon. Not that they necessarily will be, but you should take a look. Sometimes when government speaks in ways that may infringe other constitutional rights. Okay, and then the second thing I want to mention, my spiel I always do, that the First Amendment has so many cases interpreting it at the Supreme Court and also in the Court of Appeals and in the lower courts in the states and what have you. All explanations here are my own. and are not to be ascribed to my school or my students. But just so you'll know a little bit about me, I am a professor of law at Mississippi College School of Law. And I've been teaching in law schools and also in business schools for altogether about 30 years now. But all views, all explanations expressed here are my own. Now, let's get right to it. Now, does government have the right to communicate or to convey a particular message? The major case on this, and again, all of the case names and dates are in the text box, so you can look them up for yourself and read more about them, okay? Rust versus Sullivan. So here's what happened. So there was this federal law providing funding for family planning clinics. And the law said that if you accept or use these governmental funds, then you can, the clinic, the doctors, the staff, they can talk to women about various types of birth control, but they cannot counsel them about abortion. They cannot discuss abortion at all. So the question becomes, the Constitution gives women a right to choose, right? A right to choose to have an abortion. So whether or not government can do this, they're basically silencing certain speech of others. That's what maybe it appeared to be doing. But the court said, no. The court said that these clinics can still counsel women as to abortion, but not by using these funds, not if they're accepting these funds. The court said that is really not even a First Amendment issue. The court said that here, government is choosing to promote one message over the other. Government is choosing to promote other forms of family planning, not abortion. And so therefore, government has that right to speak. And the court said government was not infringing upon a woman's right to get an abortion. She could still get one. She just could not hear about it. She cannot be counseled about it from a clinic that's receiving this government funding. And of course, there was a dissent to this opinion, but that is the holding of Rust versus Sullivan. So this was one of the cases that began to talk about that, like others have this right to a speech or to a message, so should government. So let's go to the next one. It's called Pleasant Grove versus, and I'm not saying the name right, I don't think, but it's Suman, was the name of a religious group. Now, the city had a park, and the park accepted monuments that were donated, huge monuments that were donated. And some of the monuments that were donated to the government were religious in nature, religious monuments. But when the Suman religious group, they wanted to donate a monument to go in the park too from their religious group, and the government turned it down. So what did the court say? Does this sound kind of like a maybe an establishment clause or free exercise problem? The court said, no, government has a right to choose what monuments to put in the government park, because the government park has a theme. And the government isn't saying you can't have your monument. The government is just saying you can't have your monument here in this park, and the government did not want the donation. And so therefore, government was just exercising its right to have a message, its right to have a view. So the court then said something that gives me pause. The court said, the majority said, if citizens don't like the choices that their government leaders are making for this park, then vote them out. You vote them out and you get someone whose choices you like. Now, the court said that, and I started thinking, about the marketplace of ideas and all of that, but I also started thinking that if a person is a part of a minority religious group, or a minority in whatever way, how are you going to vote them out by yourselves? You'll need more votes. Now, of course, if you're part of a majority viewpoint and government is not doing as you choose, expressing a viewpoint, the message you like, of course you may, you may be able to get the numbers to vote them out. So with the court saying this, it did give me great pause, but I have the case name in the bottom. You read it and you think about it. Maybe you're comfortable with what the court says, or maybe it gives you pause too. Okay, let me give you another one. Now, this other case, maybe the marketplace of ideas works. Maybe it works slowly. I don't know. But this case was sort of for some, a surprising case. And I think when I explain it, you'll understand why. The name of it is Walker versus Texas Division, the Sons of Confederate Veterans. Okay, so in Texas, you can have a specialty tag designed, and then groups and individuals purchase the tag, like a particular message or something related to a school, alums of a school, or what have you. But in order to have your symbol or your message on the car tag, the specialty tag in Texas, it had to be approved by the commission or the board. I'm looking for the name here for the board, in order for it to be added. So the Sons of Confederate Veterans in Texas, they wanted to have a specialty tag, and on the specialty tag, they wanted to have placed the Confederate battle flag. So they filled out the form requesting the specialty tag, the Sons of Confederate Veterans, and also including about the Confederate battle flag that they wanted added to their specialty tag. So initially, the board denied their request, but then the Sons of Confederate Veterans, they filed another request the next year, essentially the same request. And so this time, what Texas did is they put the the tag request with the flag, the Confederate flag, they put it through the public comment process where people in the public could lodge comments either in favor or against this specialty flag. And there were a number of governmental officials who believed that the specialty tag would be found to be offensive. And there were people in the public who believed that it would be found to be offensive. So the Texas board then denied again the request a second time. And the Sons of Confederate Veterans brought a lawsuit against the Texas board. So how do you think the court ruled? Now, the court said that the car tags and the car tag selections that the state of Texas would approve is the government speaking a message. This is what the majority said. It is speaking a message. And here, the government has decided that it does not want to speak this message, believing that people would be offended and that this offense is reasonable, and I take it also foreseeable. So the court said that the court upheld what Texas did. The court said that it was constitutional. The government can choose not to speak by using it can choose not to allow a specialty tag that included the Confederate battle flag as a symbol on the tag. And of course, there was a dissent. The dissent said, what do you mean? The state is not speaking. The state let other people have flag designs. So this is not government speech, but that was the dissent. Now, the opinion was 5-4. The 4 more liberal justices said that Texas was justified in denying this flag, and 4 of the more conservative justices said it was not. So who was breaking the tie? You're going to find this interesting. Justice Clarence Thomas. Justice Clarence Thomas, who usually votes with the more conservative bloc of the court, voted with the more liberal justices in holding that Texas had a right to speak, a right not to speak. Texas had a right not to accept the message or not to print the message of the Confederate battle flag on a specialty tag. That's interesting. What do you think about that? Did the court get it right? And do you find it interesting that Justice Clarence Thomas voted in the way that he did? Okay, now, government says it as a message and it can speak in lots of different ways. We're not going to go into detail, but if you go to work for the government, and that's good employment, I've worked for the government before. If you go to work for the government, then you need to understand that some things that maybe you were able, some rights you had of speech before you went to work for the government, you may not have those rights in exactly the same way after you go to work for the government. Now, there's this case, and I put the name at the bottom for you to read about. It created quite a stir. It was called Garcetti versus Civilis. And what happened, there was a government employee, and this employee believed that, and I believe he was in the prosecutor's office, he believed that a search warrant had been obtained based on false information. And so he went to his boss and he said, no, this search warrant cannot stand. We cannot do this. It was obtained based on false information. We have to throw out this evidence. But his boss did not want to hear him. He kept going back. He kept going back. He thought that what they had done was wrong and they should rectify it for the good of justice. Well, he ended up sort of being demoted as a result of pushing his boss on this point. And the court did not rule in his favor. The court said that he was speaking about a matter related to his official duties. And since this was a matter that related to his official duties, he did not have the same speech rights as if he was speaking as a citizen. It's a very interesting case And for some people in academics, it became a very troubling case, especially those who work for governmental institutions, if a school could use this to try to silence a professor who is researching or teaching on certain subjects. But I have the name at the bottom, and you can take a look at this for yourself. Okay. Now, government also speaks in terms of public school education. And here we're looking at not private schools, but public schools, government funded schools, and especially focusing here on K through 12. The first case, and probably one of the main cases, is Tinker versus Desmond. Now, what happened in this case? Again, I know you're tired of me mentioning the Vietnam War, aren't you? But there were so many protests going on, and we also still had the mandatory draft. So in this case, some students, some public school students, they decided they were going to have a silent protest. So in their protest, they all were going to wear black armbands, and the black armbands was their statement that they were in opposition to the war. So they did this, and the school wanted to make them stop. The school said, no, you cannot be doing this. You're here to learn. This is going to cause some problems at the school. So their case went up to the US Supreme Court, and the court ruled in favor of the students. So the court said several things. One thing the court said was that teachers and students do not leave all of their First Amendment rights outside the schoolhouse gates, right? When you walk into the schoolhouse gates, you're not leaving all of your First Amendment rights on the outside. You carry some First Amendment rights in with you. So that's one important thing the court said. Another thing the court said was this. The court said that, excuse me, I got to cough a little bit. Let me pause. I'm back. Okay, the second thing the court said was, even though you don't leave all of your rights outside, that students' rights in the schoolhouse were not the same as the rights that adults have outside the schoolhouse. They're less, right? They're not coextensive. They're not the same. The court said because you're in school for the school's mission, the educational mission for you to learn, okay? So we have these two things here, these two tensions. And let me say that for teachers, the First Amendment right for educators is called academic freedom. And we really don't have a lot of case law that explains just what academic freedom is. But the right to control your class and how you do your exam and your speech, you have certain rights. Myself, I have certain rights of academic freedom, but those are not defined as clearly as some would like, okay? Now let's go back to Tinker. So what did the court do about this? Well, the court articulated a test. It said that to punish the students here, government would have to show that the speech materially and substantially interfered with the school's mission and order. Materially and substantially interfered with the school's mission and order. And the court held that that was not established in this case. They could wear their black armbands as a sign of political protest. Now, it just gets more interesting. So if students have speech rights inside the school, what about on field trips? Now, you've probably heard about this case. It's called Morris versus Frederick, the Bong Hits for Jesus case. Bong, B-O-N-G, Hits for Jesus case. Okay, now, the school had a little bit of an outing. There was going to be a television camera, I believe an Olympic torch or something was passing by the school. Something was passing by the school. They wanted the children to all be looking just so nice and everything because the camera would get the school children in a picture of their school. And so they were just all set. Now, there were a couple of students who they didn't show up in time. It appears it was on purpose. They came to the school later about the time everyone was lined up outside on the sidewalk. And so as the camera's about to come and everything to be on TV, they had this big banner and they unfolded the banner and the banner said, Bong Hits for Jesus. Oh my goodness, the teachers, the principal got so upset with these students. Put that thing down, put that thing down. Of course, some students complied and some did not. So can the students constitutionally be disciplined for that speech? And the case is just amazing. There were so many different viewpoints from so many of the judges in terms of whether students ought to have any speech rights at all. One justice said, you go to school to learn, sit down, be quiet, and learn. You have no speech rights. But that justice was in the dissent. This is what the court held. The court said that this banner could be taken to mean that the school is promoting illegal drug use. And for that reason, the students could be punished. They said they still have a right to speak, but not to be promoting illegal drug use. They can debate the issue, debate the legalization of drugs, or talk about it, whatever, but not like this. Now, an ongoing question is, can students be punished for speech away from the school? What if a student is engaged in speech and questionable speech, expressive conduct, what have you, and the school wants to punish the student when the student returns? Can the school do that? And that's sort of a continuing debate that is ongoing. Now, one more, and then I want to make sure I go back and point to something about all of these cases that may help you in distinguishing and arguing situations. So, Hazelwood School District, the students had a newspaper and they would write their stories and then submit the stories submitted to the principal to review prior to the paper being published. So this particular issue, the students wanted to write about some things that really mattered and mattered to their classmates. So they had an article on teen pregnancy, and this was in the 1980s. They had an article on what it's like when your parents are divorcing. And so when the principal reviewed the articles, the principal said, wait a minute now, don't know if we want them writing this. Maybe you can tell who they're talking about. I don't know, the principal wasn't too happy about it. and the court said didn't really take time to meet with the students and talk about how it could be tweaked, so to speak. The principal just pulled the articles. And so now we have a lawsuit. The students sued. And they said, I guess the first question is this a prior restraint? But the court actually ruled for the school and the principal. The court said this: educators may exercise editorial control over student speech in school as long as it is reasonably related to educational concerns. Now, there was a dissent, and the dissent said this is censorship and it is unconstitutional, that the principal and the teachers should have sat down with the students and discussed what their concerns were and how these articles could go forward, maybe with some editing or some changes being made in the stories. Now, all of this is about government speech, right, and government message. But something I neglected to point out, that when the government speaks, I think, and this is my understanding, that you still look to see if there are any alternative means of expression. So for example, in the first case, Russ versus Sullivan, if you take the funds, you cannot counsel women about abortion. And then the argument was, but a woman can still get that counseling, but not at this particular clinic, so to speak. And so the idea is that there is some alternative ways for the information to be exchanged, just not at the particular clinic. And then, for example, the case about the car tag in Texas, the Sons of Confederate Veterans, they wanted the specialty tag with the Confederate battle flag. And then the argument of the government was, well, you can still get a sticker. You can still put a sticker on your car or what have you. You just can't have this specific tag. You can still put the flag on your car in other ways. And then over with the, with Morse versus Frederick, Bong Hits for Jesus, the court said there was still, if they wanted to talk about illegal drug use or they wanted to talk about the legalization of drugs, there were still ways they could have proposed that to their teachers, but maybe not in the way they did with the banner as the television cameras were coming by. So what do you think about these cases? Should government have a right to speak or to speak or to promote a particular message? Does that in itself silence other speech? I mean, these are thoughts for you to have as you review these cases and consider them yourself. Remember, learning is so important. And as we learn more and question more, we become more enlightened. As we become more enlightened, perhaps we move closer to being really free and toward justice, or at least toward a taste of justice. Thank you. Subscribe and sign up for notifications. I'll see you next time.